A Pennsylvania courtroom, November 12, 2010. The judge asks him, on the record, "You admit that between January of 2008 and July of 2010, you engaged in the conduct just described by the district attorney?" "Yes, Your Honor." 15 years later, that man, a QAnon live streamer a lot of well-meaning people still follow, dragged the victim of that crime into court for defamation. He lost, and not on a technicality. I'm Dorian Russell, and let's separate the records from the noise. Quick reminder, this is the whole point of On the Record. Every claim gets graded by how hard the proof is. Court record, documentary, or just reported. I'll tell you which is which as we go. Everything in this video is anchored to filed court documents, and where it isn't, you'll see the red tag on screen. Before the lawsuits, let's lock down the one fact none of the noise can spin away, because it doesn't come from me, from a reporter, or from an anonymous tip. It came out of Phil Godlewski's own mouth, under oath. In 2010, Godlewski was charged in Lackawanna County, Pennsylvania. Following plea negotiations, the Commonwealth filed an amended criminal information charging a single count, corruption of minors, on the factual basis that he, quote, did repeatedly have inappropriate text messages and contact with a minor. He pled guilty on November 12, 2010. He was sentenced the following July 11, 2011, to 3 to 23 months of home confinement and prohibited from any contact with the victim during his supervision. And here's a chapter the opinions never mention. It's on the docket. In February 2011, Godlewski moved to withdraw that guilty plea. In March, the judge granted it, and the case went back toward trial. By July, he was sentenced anyway, and on the same single count, and the other 7 charges were formally dropped. He tried to take the plea back. It is still the plea that stands. And here's the part conveniently left out by anyone waving this off as just corruption of minors. That was the plea down. The original criminal complaint charged against him was statutory sexual assault, involuntary deviant sexual intercourse, aggravated indecent assault, and indecent assault. The label he pled to sounds a whole lot smaller than what was originally charged. That's in the court's own memorandum. And that's just the court summary. The docket itself lists 8 original counts, including intimidating a witness or victim, and criminal use of a communication facility. 7 counts dropped at sentencing. 1 plea. That is what a plea down looks like on paper. Now, I'm going to name her, and I want to tell you exactly why I can. The victim is Brianna DuBorgel, and the reason her name is public is explained by the Superior Court itself. She voluntarily identified herself and provided affidavits, and Godlewski identified her by name in a civil action he filed against her. He put her name in a public caption first. On the ages, the record contains a spread, and I'm not going to pick the number that sounds worse. The court ruled on this framing. He was 27, she was 15. Every source in the record agrees she was under 16, and under 16 is the fact the rulings turn on. He was the baseball coach at Riverside High School. She was a student there. 2 criminal cases, 2 civil cases. The dates interlock, and one gap in particular does more work than anything I could say. 2008 to 2010, the relationship occurs while she is a minor. July 2010, the criminal complaint. November 2010, the plea. Then, February 20th, 2020, Godlewski is charged in a second criminal case: forgery of bank records, theft by deception, tampering with records, and bad checks. After that arrest, this is the Superior Court talking, not me, the State Real Estate Commission suspended his realtor's license. Now watch February 2021 closely. On February 14th, the Scranton Times publishes Chris Kelly's column. Godlewski sued over it, and one of his central complaints was that the article impugned his fitness as a realtor, that he'd made his reputation by being trustworthy. On February 23rd, 9 days later, he stood in a Pennsylvania courtroom and pled guilty to tampering with records and bad checks. He admitted providing a fraudulent bank statement and passing a check for more than $21,000, knowing it would not be honored. He blamed a newspaper for his ruined reputation as a trustworthy realtor. The state had already taken his license over his own fraud. And here is how that case ended, straight off the docket, on June 22nd, 2021, while his defamation suit against the newspaper was 4 weeks old. He was sentenced 1 month of confinement in Lackawanna County Prison, followed by 3 months of house arrest, followed by 44 months of probation, with 12 more months running consecutive. The docket's confinement block for that day reads, "Still in custody." Yes. He asked the judge to reconsider that sentence. Denied. The same day. Now the messages. And this is where discernment matters. I'm not pulling these from a rumor mill. They live in court filings, and several of them are the literal factual basis of the criminal charge he pled guilty to. I'm summarizing the graphic ones rather than reading them. The ones that decide these cases are right here. First, he knew her age and said so. From his own day log, recovered in the forensic analysis and quoted in both opinions, quote, "Realize that you're only 15 but quickly stopped caring," end of quote. That single line torches any "I didn't know" defense. Second, the 2022 texts, the ones most relevant to the live case. No sexual content in these. In May of 2022, while his lawsuit against the newspaper was pending, Godlewski texted the woman he had pled guilty to corrupting about, quote, "a financial windfall," and being, quote, "literally foaming at the mouth to take them down once and for all." The newspaper's lawyers called that an attempt to solicit perjury. That characterization is theirs, not a court's. No judge has ruled on it. But the text itself is in the record, Bates stamped, attached as an exhibit to a filed brief. Documentary Tier 2. So he sued the Scranton Times for defamation, and here's how that ended. In August 2024, the trial court granted the newspaper summary judgment, and in September of 2025, the Pennsylvania Superior Court affirmed. Quote, "We affirm." The reasoning, in the court's own words, the evidence reflects that he pled guilty to sending inappropriate text messages to a minor, and in those messages, he admits to a sexual relationship with a minor. He could not prove the statement was false, and he could not show actual malice, a burden he took on himself by stipulating that he is a public figure. 1 point of precision, because his side will hunt this video for any error. That decision is a non-precedential memorandum. It does not make law. It is, however, completely binding on him, and it affirms. Now, the newspaper's own exhibit, because this is the beat almost nobody has seen. 2 days before the column ran, the columnist texted Godlewski directly. He named both criminal cases, the underage girl and the check case, and said they would likely be in his column. Didn't want to blindside you, he wrote. Godlewski's answer in full, quote, "That shows your character as a journalist. Take care, Chris. You just lost all respect and credibility with me." End of quote. No denial, and an attack on the messenger. Later that same day, asked point blank whether he was at the Capitol on January 6th, he answered, "No, I wasn't. But Chris, please stop messaging me. Bringing up my past only serves you." He denied the Capitol, proof he knew how to deny a thing that wasn't true. The criminal cases he called my past. And on the day the column ran, quote, "My attorney is Lynn Wood. My 100,000 plus followers are funding my legal costs." End of quote. The lawsuit and the fundraising announced in the same message the same day. Why this matters legally. Actual malice turns on what the writer knew and believed. This exhibit shows the columnist put both cases to the subject in advance and got no denial. One more set of entries from that same era, and I'll give you exactly what the docket shows and nothing more. In May of 2022, a year into his lawsuit, someone moved in the 2010 criminal case for access to sealed records. Godlewski, through the same attorney signing his defamation filings, filed in opposition. The docket doesn't say what's sealed, and it doesn't show how the motion resolved. So neither will I. What it shows is the posture. The man publicly insisting the record vindicated him was, that same spring, in court opposing access to part of it. In March 2023, Godlewski sued Brianna DuBorgel, claiming her sworn affidavit about their relationship was false. She counterclaimed defamation, false light, assault, battery, and infliction of emotional distress. In April 2025, Judge James Gibbons ruled, and there's one paragraph his side will hunt for an error in. So here's the whole claim with no shortcuts. In the newspaper case, a judge had once written that Godlewski was collaterally estopped from denying the relationship. A month later, that same judge corrected himself. The doctrine and its 5 elements, he wrote, were never cited or expressly applied. Her lawyers cited the original line to Judge Gibbons anyway, and Gibbons rejected it under a section heading that reads, "In the memorandum itself, Godlewski is not collaterally estopped." He gave 2 independent reasons. The elements of the doctrine were never fulfilled, and she had waived that defense by failing to plead it. Both grounds, not one. That's the precision his side is counting on this video to miss. And then the holding that actually matters. Godlewski cannot deny the existence and validity of the text messages because of his own guilty plea. Same wall, different bricks. He is not collaterally estopped. He is simply a man who pled guilty and who therefore cannot stand in a civil courtroom and say the messages that convicted him don't exist. So the rulings. His defamation claim, gone. Truth is a complete defense, and the court found no genuine dispute about the truth of her affidavit. His false light claim, gone. And here's where the phrase everyone quotes actually appears. It is impossible, the court wrote, for her to have acted in reckless disregard of falsity, because the statements in her affidavit are undeniably true. And her counterclaims for assault and battery, granted, in her favor. On his argument that she consented, the court's entire response was, "We completely disagree. A minor under 16 cannot consent. Liability is established. Only damages remain." He tried to appeal that ruling immediately. Here's what really happened, because this beat gets spun hard. He filed his petition in the Superior Court before the trial court had even ruled on his application to certify the appeal. The Superior Court ordered him to show cause why it shouldn't be dismissed as premature. He consented to the dismissal. In December 2025, the Superior Court dismissed the petition without prejudice. And note the asymmetry. The decision he lost in the newspaper case was non-precedential. The one place he actually made Pennsylvania law is the opinion explaining why his appeal was premature. Now put the December dates side by side, because the docket does something here that no press coverage has touched. On December 4th, 2025, 2 new attorneys entered appearances in the 2010 criminal case. On December 5th, a petition for post-conviction collateral relief was filed. And if those names sound familiar, they should. They are the attorneys on his civil filings. The civil team walked into the criminal docket. 13 days later, the Superior Court dismissed his civil appeal. Sit with the shape of that. His case has died because his own guilty plea bars him from denying the text messages. So now, 15 years after sentencing, he is attacking the plea itself. The Commonwealth has answered. He has moved to amend. It is pending as of this recording. The single fact every court so far has treated as immovable is the fact he is now asking a court to move. The case stays in Lackawanna County. It is not going anywhere. And the criminal docket, dormant since 2013, is awake again. Doing this right is the whole point. So here's everything in the record that helps him, or complicates the story, before anyone can accuse me of hiding it. 1. He was offered his say, repeatedly, on the record, before publication. This channel doesn't do pre-publication comment requests, so it matters that the original columnist did. The filed thread shows the columnist asked for an interview 3 times over 2 days, including an offer to record the interview on consent. Godlewski refused every time, writing that anything he said would be, quote, dissected into oblivion. That's his stated reason, in his own words, unedited. But the offer was real, it was repeated, and he declined the record. 2. Her affidavit was prepared by, or at the direction of, the newspaper's own lawyer. His side says that makes it manufactured. The court's answer, the statements in it are undeniably true, and his own plea bars him from denying the texts that prove it. 3. The same affidavit says the relationship resumed when she was an adult, in 2014 to 2016. That's in the record, and I'm not going to pretend it isn't. It changes no law. The assault and battery ruling rests on 2008 to 2010, when she was a child and could not consent as a matter of law. 4. The alleged suicide threat you may have heard about, that he threatened to take his own life to stop her cooperating. The court itself noted she failed to produce evidence of date, time, or method, so that allegation is reported, not record, and it wears the red tag. And 5, he won 1 count. Her claim for intentional infliction of emotional distress was dismissed. She missed an expert deadline. That is a real win, and I'm counting it. There it is, the documented record, start to finish. No inside sources, no fantastical claims, just filings, rulings, and a man's own guilty pleas. Whatever Phil Godlewski tells his audience he is, this is what the courts of Pennsylvania say he is. He pled guilty to corrupting a minor. He pled guilty to fraud. He sued a newspaper for saying so and lost. He sued his victim for saying so and lost worse. She now holds an established liability finding against him for assault and battery, with only damages left to argue. I'll update when the trial court rules on the certification application. if the Superior Court takes the appeal, when a damages phase or trial date lands, and when a court rules on the PCRA. And I'll move every claim up or down the tiers as the documents land. Verify everything. Discernment is everything. I'm Dorian Russell. Check the receipts.